Welcome, everyone, to the Bold Inventor Show. I'm your host, JD Hubiner, owner, founder, and patent attorney here at Bold Patents Law Firm. Excited to be with you all here. So today we've got a good show. I'm going to discuss what the reason why one patent is oftentimes not good enough. Okay, that's the topic today, and why a portfolio, right, family of patents should be what you should go for when you're looking to secure an invention. Okay, and what the differences are, what a parent and a child application are. If you do want to seek a legal consult, please click that link above, and I highlight that here just below. It's our weekly live link for scheduling that free discovery call to see if our firm is a good fit. You get a copy of this book behind me, you'll get a PDF download and learn all about what patents, trademarks, copyrights, and trade secrets are. So first topic of the day, why one patent is not good enough, okay? And I don't want to, come off as being like, yeah, of course, like millions of patents, come file them all with us. We're greedy. No, the whole point is that we want to protect your invention. And that is the goal. But it isn't just the invention, it's actually what you're selling. So at a really high macro level, the whole idea about getting a patent is to make sure that you, the inventor, are rewarded for your innovation, right? For bringing that product to market and being the first to do it. The US government promises to give you 20 years of protection, being the only player, the only person in the market to make, use, or sell your invention for that period of time. So you better make for darn sure that what you're actually selling is what you got a patent on. It happens all too often, and I see it, where we kind of rush through the patent process with an early version of their design. And after getting customer feedback, after the second or third change, they tweak it so much, right, over the course of the next year or 2 years after launch, that it's a totally different product. And the features and benefits that customers want aren't even protected. And so what can happen is competitors can come in, right, and offer those same bells and whistles and have a different core component that doesn't infringe the base patent. So you've kind of lost that edge, right, that reward, that benefit that is federally backed, and the whole reason for getting a patent. So how do you prevent that? How do you prevent others from designing around yours once you hit the market? That's by getting more than one patent. So I'm going to share my screen. We're going to go through this patent portfolio guide together. So what is a patent portfolio? Portfolio is a fancy term, just means more than one patent. It's for many inventions, okay? It wants you to protect what's being sold on the market. There are two types of patents that applications we're talking about here: parents and child. So for parent applications, those are those that the first application that's filed, whether that's a design, a utility, provisional or non-provisional, it's that first filing. A child patent application is anything filed before, don't miss that, before the parent application issues. So that's a big one, I bolded that. A lot of text here. Just remember there's four main types of what are called child patent applications. The first one, and probably the most common, are divisionals. The second, continuation applications. The third one is called continuation in part. And the last one is a design application. And this really comes into play when you file the utility application first and come back later to file the design application. So a divisional, and we'll get into some of the nuances here, is that when an examiner reviews the application at the patent office, their first job is to make sure that what you submitted is only one invention. If you send in more than one invention on the same application, they're going to stop right there and say, you know, you've got more than one invention here. You've got to pick which one you want me to examine. So that's called a restriction requirement. And so after that restriction requirement comes in, you'll pick which invention you want to proceed with and reserve the right to file and protect those other inventions. Those could be future children of the parent application. The beauty there is that they share the common specification and the same filing date. So they get the benefit of that earlier filing. So any inventor that comes in later files on the same subject matter as one of those other divisionals, they will lose to you. You will win the race to the patent office. Now, continuation application is where you've got something new you're going to add, that other bell or whistle, that other different thing that customers have been asking for. And you add that in and claim it but using the same core patent application and spec that you used in the parent application. So a continuation application, you're not adding new matter. A continuation in part, that's when you are adding something else. A design application is where you only want to claim what something looks like. This can be very powerful for like consumer products or three-dimensional objects. I mean, like a cup or a mug, go big, go bold, where you want to protect, something apart from its functionality. A utility patent only protects what it does, whereas a design patent protects the way that it looks. So something like the iPhone, right? It's going to be protected, of course, by maybe hundreds of utility patents governing the software, the way that it functions, how it's ergonomic. But the design patent is also protected, right? The way it looks, the mere appearance of it is also protected. So there's lots of different ways and timelines to file. You could end up with 5, right? Your parent and 4 separate types of children or more in your portfolio. The other huge benefit to having multiple patents is that once your parent patent application issues, you now have other children that are still pending. This is probably the biggest secret here in patent law. This is one of the biggest benefits, is that you've got the ability to now change your patent application that's still pending. So let's say you sell your product, it gets on the market, and now you've got a competitor trying to design around you. Let's use the example of a water bottle. I usually use this because it's handy. Okay, so this is your parent patent application got issued, and it's mostly governing this top mechanism. Okay, so Contigo probably does have a patent, or Hydra Peak probably has a patent on this, right? Where they've got the top mechanism. So let's say a competitor comes in and they're trying to use, well, they're not going to have this handle attached, but they're going to have just a simple compression, right? And they're using rubber gaskets, and they've got a certain, amount of pressure they're pushing down on, and that seals it, believe it or not, just by pure compression. If you have a pending application, you could add, if you were Hydro Peak, potentially a claim that has the same pressure type of closure as what's on the market attached to your handle. So now the competitors will be infringing as soon as that child patent issues. It's a really powerful way to keep out competitors even after your parent gets granted.